मरते हैं आरज़ू में मरने की, मौत आती है पर नहीं आती। मिर्ज़ा गालिब के इस शेर का उल्लेख करते हुए जस्टिस काटजू और जस्टिस मिश्रा की पार्ट ने 2011 में अरुणा शानबाग के मामले में सुनवाई करते हुए निष्क्रिय इच्छा मृत्यु की इजाज़त दी थी। The Supreme Court verdict allowing living will and the right to die with dignity takes us back to Aruna Shanbaug, who laid in a vegetative state at KEM Hospital, Mumbai for 42 years. Our group will be showcasing a similar scene in a form of a short play.
डॉक्टर साहब, हम अपनी दादी को इस हालत में अब और नहीं देख सकते। पिछले इतने सालों से हम अपनी दादी के इलाज में इतना पैसा और पसीना बहा चुके हैं कि अब हम और नहीं कर सकते। आप ही कुछ हमको बताइए कि अब हम क्या करें।
सालों से हॉस्पिटल भी इसी प्रयास में लगा हुआ। आपकी समस्या से हम भली भांति परिचित हैं, पर अब क्या चाहते हैं, हम क्या कर सकते हैं?
हमने सुना है कि अमेरिका में इंसान को एक इंजेक्शन लगाकर उसको इस दुनिया से मोक्ष प्राप्त करवाया जाता है। अगर ऐसा कुछ है तो हम चाहते हैं कि आप हमारी दादी को एक ऐसा ही इंजेक्शन दे दीजिए।
देखिए, अमेरिका में तो ये कानून लागू है, पर हमारे देश में यह भी गैर कानूनी, इस पर भी कोई कानून नहीं बना है, तो ये हमारे अधिकार क्षेत्र के बाहर आता है। अभी हम ये बिल्कुल भी नहीं कर सकते।
The right to life and personal liberty is one of the most significant fundamental rights that acts as a facilitator of other fundamental rights. But the question is whether a person's life includes the right to die. This question was answered in the case of Common Cause versus Union of India. Good afternoon to everyone present here. Today, Group 4 will be enacting the case of Common Cause versus Union of India. This petition was brought by Common Cause, a registered society, which sought a declaration that the right to die with dignity formed a part of the right to live with dignity under Article 21 of the Indian Constitution. It further sought directions to the state to adopt appropriate procedures to allow persons who were of deteriorated health to execute living wills. We will see how the court extensively considered Indian and international precedents and held that the right to die with dignity was a fundamental right under Article 21.
Before we dwell onto the details of this case, let's first understand the concept of euthanasia. The term euthanasia is derived from a Greek term which means good death. It is practice of ending a patient's life in order to relieve their suffering. Normally, the patient in concern would have a serious illness or be in excruciating pain. Euthanasia would allow an individual to have a comparatively good death as opposed to sentencing them to slow, excruciating or undignified demise.
The main legal question raised by this case is whether the right to life includes the right to die with dignity. The issue can be traced back from the case of Aruna Ramachandra Shanbaug. The major difference between the Shanbaug case and the Common Cause case is that the former legalized passive euthanasia, but the latter basically included the right to die with dignity with right to life. The first scene will open up to show that the petitioners urged the Ministries of Law and Justice and Health and Family Welfare to legalize euthanasia and living wills through a letter. In this particular act, we are showing the same via a call.
Hello. Am I speaking with the ministry representative?
Yes, this is Ministry of Health and Welfare. How can I help you?
मैम, मैं एक NGO कॉमन कॉज से बात कर रही हूँ और हम लोगों के इंडिविजुअल्स के सोशल नीड्स को केटर करते हैं। कुछ टाइम पहले हमने आपको एक लेटर भेजा था रिगार्डिंग द लीगलाइजेशन ऑफ यूथनेशिया, बट वी हैव नॉट हर्ड फ्रॉम यू सिंस देन।
See, as Ministry found it highly unfavorable to get euthanasia as the need. It's depend on case-to-case basis and there is no uniform laws related to it.
Common Cause filed a public interest litigation in the Supreme Court under Article 32 of the Indian Constitution after not obtaining a response from the ministries seeking the recognition of euthanasia and living will for terminally ill patients and people in permanent vegetative condition. Court then appointed an expert committee to determine this aspect. A 3-judge bench of the apex court referred the matter to a larger bench to settle the issue considering inconsistent opinion in Aruna Shanbaug versus Union of India and Gyan Kaur versus State of Punjab. The next scene will depict the Supreme Court proceeding in which a 5-judge bench presided over this case. Right now, we'll see the contentions of the petitioners.
Good morning to the honorable bench. Counsel seeks permission to approach the dais. Granted.
The council is pretty before the court in the case of Common Cause versus Union of India, and the council is speaking on the behalf of petitioner. Our Lordship, there are two main issues that are raised into the petitioner. First, the right to die with dignity should be included under the ambit of right to life granted under Article 21 of the Constitution. The right to self-determination or the right to choose for oneself is already mentioned under the Article 21 of Indian Constitution. Every individual should have a right to decide for themselves, knowing that they are suffering from a chronic disease that is likely to put them into a vegetative state. This not only gives them an anatomy, but also gives them a merciful way.
But Learned Counsel, how are you supposed to prevent abuse of such rights?
Indeed, Your Lordship. The Council urged the state to appoint a committee of experts including doctors, social scientists and lawyers for issuing guidelines regarding living will and to issue further direction and guidelines as may be necessary. Your Lordship, the Court of Missouri, USA held that using advanced medical techniques to keep a patient alive in a persistent vegetative state prolonged the pain, suffering, and was an infringement on their anatomy and dignity. The Supreme Court in Gyan Kaur versus State of Punjab held that right to life with dignity falls under Article 21 of Indian Constitution. So isn't subjecting individual to painful treatment in contravention to this? In the case of Aruna Shambaug, whereas a woman was brutally raped and bodily injured in such a state that later she was in a vegetative state. Why was she forced to live in such a state for 42 years? Even after the failure of various medications, does this defeat the whole purpose of the legislation? Is this right to dignity? Moreover, Law Commission 196 report recommended legislation passive euthanasia. It is also mentioned that a patient can orally or in written request seek removal or support system. Therefore, the Council humbly prays before the court to include the right to die with dignity and the power to exercise living will.
The following scene will show the arguments of the intervener representing the society. Good afternoon, Your Lordship. The Council seeks permission to approach the right. Granted. Your Lordship, the Council is appearing on behalf of the intervener. The court has accepted the intervention of society. The affidavit in support of euthanasia has already been submitted. Your Lordship, the contention of intervener in the same is that from the time of Plato to the time of Sir Thomas More and other thinkers, painless and peaceful death has been advocated. It has been stated in the affidavit that there is a need to have a mechanism which can ensure a calm departure of an individual from life, leading to less pain and suffering. Your Lordship, the freedom of choice also includes the freedom to choose whether to live or not to live. This freedom entitles the person to choose death rather than being in a state of irrevocable ailment. Moreover, the Council on behalf of society prays before this Honorable Supreme Court to allow the patient to execute a living will, which will ensure the persons of deteriorated health and terminally ill patients should be able to execute a document which can later be presented to hospital for appropriate actions in the case the patient suffers or undergoes vegetative state of mind and body, the sample of which has already been attached with the affidavit.
But counsel, don't you think it's the duty of doctor to preserve one's life rather than taking it away?
Indeed, Your Lordship, a doctor's main duty is to preserve life. In the case of euthanasia, a doctor's duties are in conflict. On the other hand, the doctors do have a duty to relieve the patients from their suffering also.
The following scene will depict the arguments of the respondent.
Good afternoon to this honorable bench. The council seeks permission to the respondent's arguments. Your Lordship, the Ministry of Health and Family Affairs submitted a counter affidavit in the court and stated that they find it highly unfavorable to regulate euthanasia, as the need for euthanasia is entirely dependent upon a case where uniform laws cannot be made. Your Lordship, it is asserted that the right to die with dignity does not form a component of right to live with dignity. In Gyan Kaur versus State of Punjab, Section 306 of Indian Penal Code talks about abatement to suicide and 309 of Indian Penal Code was challenged. Your Lordship Court upheld the validity of these two provisions and overruled the decision in P. Rathinam case. Lordship, Your Lordship, right to life under Article 21 did not consider right to die. It has been stated that right to life is an innate liberty in our constitution and suicide is an unusual way to end one's life. It did not consider a fundamental right in our constitution.
Counsel, how can a person be prosecuted under Section 302 of the Indian Penal Code for abetting the commission of suicide, which is stated under 306 of the Indian Penal Code? Along with that, when the person who commits the suicide is not liable for the punishment under Section 309 of the Indian Penal Code.
Indeed, Your Lordship. Section 309 of Indian Penal Code criminalizes attempt to commit suicide, but it does not apply to those who actually committed suicide. However, Section 306 of Indian Penal Code abating the commission of suicide, which includes encouraging or instigating a person to commit suicide.
The judgment was delivered on 9th March 2018. The following scene will depict the final order of the Apex Court. Keeping all the facts, this court is of the opinion that under Article 21, individuals have the right to die with dignity as a part of their right to life. It permits the removal of life support system for the patients who are terminally ill and also for those who are under some incurable disease or the patients who are in a coma for a long time. We allow the individuals to decide against the artificial life support and also to recognize the need for creating a living will. It is a step towards protecting the right to personal autonomy and self-determination where the patients are unable to make an informed decision.
The judgment in this instance exemplifies how the concept of proportionality was used. It demonstrates how the court weighs the two facets of the same right, in this case the right to life under Article 21 of the Indian Constitution. While the right to life inspires a strong governmental commitment to protecting human life, it also ensures a person's autonomy in making decisions about his or her own health. It has provided an exception to the concept of the sanctity of life in cases when a person's life has lost meaning and extending his life is no longer in his best interests.
To conclude, the court maintained the privacy autonomy matrix guaranteed by the Indian Constitution. It maintained the ability of a person who is competent in giving permission to advance directives and attorneys' authorizations to suspend ineffective medical treatment or life-supporting technology in cases where the patient is terminally ill or in persistent vegetative state. Mortality is not an adversary and rather an undignified extension of life. And a dignified death is a reason to celebrate.